This is Beyond Borders, the immigration evaluation podcast, where you'll learn how to confidently conduct evaluations, connect with attorneys to gain referrals, and create a thriving practice. I'm Dr. Mariella Shibley, and I am here to help you turn your expertise into impact. Let's get started. Today's episode is a little different, and I'm really excited about it. So this episode is based on my workbook, The Introduction to Immigration Evaluations. And I created that workbook for mental health professionals who are curious about this field and want a clear, structured overview of what immigration evaluations actually involve. But I know not everyone prefers to read, so some of you like to listen while you're driving or walking your dog or folding laundry. So this episode is essentially the audio version of that workbook, where I walk you through the major concepts, the types of cases, and the role that we play as mental health professionals in immigration proceedings. If at any point you decide you'd prefer to read the workbook instead or follow along, then you can go to psychevalcoach.com and click the top banner, and a copy will be emailed directly to you. So let's just dive in. Okay, so why immigration evaluations matter? Immigration evaluations are, in my humble opinion, one of the most meaningful spaces where psychology intersects directly with the legal system. And I don't say that lightly. In many areas of forensic work, we provide helpful information. We clarify, we assess, we offer professional opinions that become one piece of a larger puzzle. But in immigration cases, our role can be far more than just supportive. It can be decisive. In this field, your clinical skills are not just useful, they can really determine outcomes. So when an immigration judge or a USCIS officer is reviewing a case, they're often looking for evidence that goes beyond legal arguments. So they're asking, what is the real human impact here? What would actually happen to this family? What are the psychological consequences of deportation, of separation, or forced relocation? And that is where we come in. We are often brought in to document the emotional and psychological hardships that people would experience, trauma that perhaps resulted from violence or persecution or abuse, the impact of domestic violence, the mental health consequences of criminal victimization, evidence of rehabilitation after past offenses, competency to participate in legal proceedings, cognitive or psychiatric disability for naturalization exemptions. In other words, we translate human suffering into clinically grounded, legally relevant documentation. And when we do this well, when the evaluation is thorough, objective, and clearly tied to legal standards, it can carry enormous weight. I've seen cases where a psychological evaluation was the turning point. I've heard attorneys say, this report made the difference. So if you heard the episode with immigration judge David Kolsch, you heard him say exactly that. And I have seen families stay together because a clinician took the time to carefully document the emotional reality behind the legal paperwork. And that's not an exaggeration. In immigration law, decisions can ultimately mean that a parent remains with their children or is separated for a decade. A trauma survivor can find safety or is returned to the place where they were harmed. A spouse is protected from abuse or remains legally trapped. A refugee is granted protection or they're deported. So these are life-altering outcomes. And unlike many areas of clinical work where change unfolds gradually over months or years, here your assessment can have immediate and complete legal impact. And that is both a privilege and a responsibility. It requires clinical skill, it requires ethical clarity, it requires cultural humility, and it requires understanding how to write for a legal audience without losing psychological depth. So to make this more concrete, I'm going to talk about a fictional case, one that pretty much mirrors very real situations that I've encountered over the years. Because when we talk about extreme hardship or inadmissibility in abstract terms, it can feel kind of distant. But when we look at a family, at a person, it becomes very real. So let me tell you about Sophia. So Sophia was born in Mexico, and when she was about 2 years old, her parents brought her to California. They made their way with a human smuggler, and they settled in San Diego. So Sophia went to school. She had friends. She built her entire identity here. She also had some younger siblings who were born here in the U.S. And when she was about 16, she tried to apply for a driver's license, and that is when she discovered that she was undocumented. Now, fast forward several years, she marries Jake, whom she met in high school, and he is a U.S. citizen. So they marry, they have a baby, they build a life together, and once they feel financially settled, they say, hey, we should probably go and apply for your green card. Now, when they go and consult with an immigration attorney to adjust her status, they learn that because she entered without inspection and she stayed in the U.S. unlawfully and some other caveats like legal nuances that I'm not going to get into, bottom line is if she leaves the U.S. for her immigration interview, which is what she's supposed to do in order to adjust her status, she will trigger a 10-year ban from returning. So in other words, she married Jake, who's a U.S. citizen, totally legitimate. They can apply for a green card through him via marriage, but because of this, what is referred to as unlawful presence, she would have to serve a ban before she can lawfully reside in the U.S. And because this case was being handled what they call consular processing, meaning that she would have to leave the country to go to the U.S. Embassy in Mexico to have the interview and adjust her status. So the minute she leaves the country, she triggers that 10-year bar. So now they're faced with these choices, right? Do they separate for 10 years? Does she take the baby to Mexico or leave the baby here with Jake? Does Jake close his business and move to Mexico and all three of them live in Mexico, which is technically a foreign country to both of them because she has never been back since she was brought here when she was 2? Or are there any other options? And the only other option may be what's called a waiver of inadmissibility. So what is a waiver of inadmissibility? A waiver is essentially a legal pardon, and it allows someone who's otherwise, quote unquote, inadmissible to remain in or return to the United States. So there are many grounds of inadmissibility, meaning that makes someone not able to stay or to enter the United States. One of them is unlawful presence, like the case of Sophia and many, many, many other cases. There's also grounds of inadmissibility if somebody has a criminal conviction, if they've committed fraud or misrepresentation. And by that, that could be anywhere from using fake papers to making a mistake on a form or not including something that they didn't think was important, things like that. Public charge concerns, that is people who use government benefits, and health or security issues. So to qualify for many waivers, the applicant has to show that their removal would cause, and this is a legal term, extreme hardship to a qualifying relative. So qualifying relative is typically a U.S. citizen or lawful permanent resident, spouse, or parent, and sometimes a child, depending on the type of waiver. So this is where we come in. A psychological evaluation can document the emotional, psychological, and sometimes functional impact that separation or relocation would have on the qualifying relative. So in Sophia's case, Jake would likely be referred for a psychological evaluation to demonstrate how her departure would affect him emotionally and psychologically. Now, I mentioned extreme hardship. Extreme hardship is a legal standard, and it's important to understand what that really means. It doesn't mean ordinary stress. Immigration law already assumes that separation is difficult, that's expected. But extreme hardship means that hardship beyond what is typically expected when families are separated because of immigration enforcement. So it means the emotional, psychological, medical, financial, or social consequences that would be significantly more severe than the norm. So USCIS, that's the United States Citizenship and Immigration Services, they consider emotional and psychological impact, economic hardship, loss of social ties, cultural and linguistic barriers, medical or health concerns. So we're looking at questions like, for example, would this person develop major depression if their spouse were deported? Would a pre-existing anxiety disorder significantly worsen? Would relocation create profound isolation or destabilization or expose them to discrimination or danger? So the standard is high, and not every case qualifies. And that is exactly why a thorough, well-documented psychological evaluation can be such a vital piece of evidence. Now, of course, hardship is assessed on the aggregate, meaning that it doesn't have to be any one particular thing that rises to the level of extreme. It could be a combination of things. And the psychological portion, it could just be one of the elements. So our job is to move the discussion from this would be hard to here's a clinically grounded reason this hardship rises to an extreme level, which of course we would never use those words in a report. That's for the adjudicator to determine if it rises to that level, but we will say that with other words. And that distinction really matters. Now, in some cases, when unlawful presence is the only issue, individuals may apply for what's called a provisional waiver, which is technically a waiver, same thing, they need to prove the same thing, but they can apply for it while they're still here in the U.S. And whether that gets approved or not sometimes marks whether they're going to continue to move forward with their immigration application. So for us evaluators, it technically doesn't change much. The only difference is that sometimes when a person's applying for a waiver, they may already be separated from their spouse. So in those cases, of course, we're looking at hardships that are already occurring, right? But when there are other situations where they're still together here and they are applying for this waiver in order to be able to move forward with their immigration case, then those are cases where we basically have to speculate on how this person would be impacted in the case of a separation or a relocation. So along those same lines, let's take Sophia's situation, let's shift it a little bit. So imagine that instead of proactively consulting an immigration attorney, Sophia is pulled over one day for a minor traffic violation, and during the stop, her undocumented status is discovered. So she is detained and placed into removal proceedings or deportation. So now we're in a totally different legal arena. Removal proceedings means that the government is actively trying to deport her. So she now has to appear before an immigration judge, whereas waivers are adjudicated administratively. In this case, she has to appear before an immigration judge, and the stakes are immediate and very real. Now, in this context, one possible form of relief could be cancellation of removal. And cancellation of removal means that the respondent, that would be the legal term for Sophia, needs to prove that her removal from the U.S. would cause her qualifying relative, which in this case would be Jake, her husband, hardship. But here's a critical difference. The hardship standard for cancellation of removal is significantly higher than for a waiver. So instead of extreme hardship, the law requires proof of exceptional and extremely unusual hardship to the qualifying relative. So that just shows us how elevated the burden is. So for Sophia, this would mean demonstrating that her removal would cause exceptional and extremely unusual hardship to Jake, or perhaps their child. In these cases, children do qualify. Now, we're not talking about just significant distress or inconveniences. It's hardship that is substantially beyond what most families would experience in similar circumstances. So now, for example, you can imagine Jake. Jake might be the sole financial provider. He may rely on Sophia emotionally. He may rely on her to care for their kid. Their child may be deeply bonded to her as a primary caregiver. So if Sophia were deported, then would Jake stay with the baby, or would she take the baby with her? Would Jake then develop severe depression? Does he have a history of depression already that would predispose him to that? Would relocating to Mexico together create instability, language barriers, most importantly, lack of access to healthcare if that's something that they rely on? So in removal proceedings, the judge has to weigh these realities carefully. And again, this is where a psychological evaluation can be especially powerful. We're not arguing the law. We're basically documenting the clinical consequences. So for this, we again assess vulnerability. We evaluate mental health history. We consider risk factors. We analyze protective factors. And we determine how likely it is that this family, Jake in particular, would experience profound destabilization. And because the hardship standard is so high in removal proceedings, the evaluation must be especially careful, objective, and well-supported. This is not about dramatizing suffering. It's about clearly articulating when the hardship truly rises to a level that is exceptional and extremely unusual, which, again, we wouldn't use those words in a report. Now, for many clinicians, this is where they realize just how consequential this work can be, because in removal proceedings, your evaluation may be read directly by an immigration judge and might be the deciding factor of whether a family stays together or is separated. Now, immigration law also includes humanitarian protections. So let's imagine some different scenarios for Sophia. So imagine that Jake is not the supportive spouse that we originally described. Instead, imagine that over time, the relationship becomes controlling, then verbally abusive, and then physically abusive. So Sophia feels trapped. And this is where many undocumented spouses feel especially vulnerable. An abusive partner may say to them, well, if you leave me, I'll call immigration. You'll be deported. You're never going to see your child again. And so immigration status can become a tool of coercion. And this is where VAWA comes in, the Violence Against Women Act. So despite the name, VAWA protections apply to individuals of any gender who are victims of abuse by a U.S. citizen or lawful permanent resident spouse, or it could be a parent or adult child. So what VAWA does is it allows the victim to self-petition. That means that they can apply for legal status without the cooperation or even the knowledge of the abusive spouse. And that's incredibly important because in many abusive dynamics, the immigration paperwork itself becomes part of the power imbalance. Now, where do we come in as mental health professionals? Well, in VAWA cases, our role is typically to evaluate and document the presence and pattern of abuse, the psychological impact of that abuse, symptoms of trauma, depression, anxiety, PTSD, coercive control and intimidation and its impact on the person, the emotional consequences of remaining in the relationship, and sometimes the impact of the abuse on the children as well. Now, importantly, abuse in VAWA cases does not have to be purely physical, okay? We understand that emotional, psychological, financial control, isolation, those types of abuse can be extremely powerful and psychologically damaging, and in particular, threats related to immigration status. These are forms of coercive control that can be just as damaging and sometimes even more so than physical abuse. But unfortunately, it's sometimes harder to document these experiences. So what we do is we assess credibility through clinical consistency. We look for trauma symptoms. We consider whether the presentation aligns with known patterns of domestic violence. Now, our job is not to advocate or exaggerate. It is to carefully, objectively, and compassionately document the psychological reality of the abuse. Now, in many cases, survivors have never talked in detail about what happened to them. So the evaluation can become the first space where their experience is validated and organized into a coherent narrative. And from a legal standpoint, a well-written psychological evaluation can help demonstrate that the abuse occurred, that it had real psychological consequences, and the individual qualifies to self-petition under VAWA protections. So this work requires trauma-informed interviewing, cultural sensitivity, an understanding of power dynamics in abusive relationships, and careful documentation. But when done well, it can provide a pathway to safety for someone who believed they had none. And that, again, is where psychology intersects directly with legal protection in a very real way. Loving this episode? I've got something to make your life even easier. Grab my free introductory guide to immigration evaluations linked in the description box. It's a game changer for ensuring your reports meet legal standards. Let me know what you think. Now, shifting gears a little bit, let's imagine a different scenario for Sophia. She never married Jake. She is undocumented. And one night she becomes the victim of a serious crime. So, for example, sexual assault. So she reports the crime. She cooperates with law enforcement. She provides information. She testifies if needed. So out of something traumatic and devastating comes a potential form of relief, and that is the U visa. So the U visa was created to protect victims of certain serious crimes who have suffered substantial physical or mental harm and who are helpful or likely to be helpful in the investigation or prosecution of that crime. So the idea behind it is twofold. One is to protect vulnerable victims, and the other is to encourage cooperation with law enforcement. So basically is a you help us, we help you. And the reason this came about was because undocumented individuals are not very likely, and still, even with a U visa, they are not very likely to report crimes out of fear that they will get in trouble. And this is something that a lot of abusers actually use against them. They will say, if you call the police, they will arrest you. And we see that in VAWAs, and we see that in U visas as well. Sometimes the U visa is for a case of domestic violence where they don't meet all the criteria to qualify for a VAWA, but they do qualify for a U visa. So I don't want to confuse you too much. Basically, to qualify, the individual has to demonstrate that they were the victim of a qualifying crime, that they suffered substantial physical or psychological harm, that they were helpful to law enforcement. So for this, they need an actual form that's certified by law enforcement saying, yes, this person was a victim of a crime, and law enforcement certifies that cooperation. And so this is where we come in. In U visa cases, our role is typically to evaluate and document the substantial mental harm resulting from the crime. And substantial is important. We're not just noting distress. We are assessing potential PTSD symptoms, depression, anxiety, panic attacks, sleep disturbance, hypervigilance, avoidance, shame, guilt, functional impairment. And in all these things, we evaluate the severity, the duration, We assess how the trauma has disrupted daily functioning, that is, their performance at work or in relationships, parenting, etc. Now, the interesting thing here is that there is no statute of limitations for a U visa, so the crime could have happened many years ago. So by the time we see them, they may not be suffering so much. But the question here is the harm that resulted from the crime at the time. And in many of these cases, survivors have never received mental health treatment. So they don't have records. And also there is a tendency sometimes to minimize symptoms. They might feel embarrassed or they might blame themselves. So the evaluation process really requires trauma-informed interviewing skills and careful clinical formulation. We are documenting the psychological footprint of the crime, and in many cases, that evaluation becomes a central piece of evidence demonstrating that the harm was real, significant, and sometimes ongoing. Now let's shift again. Imagine Sophia took a job after high school. She doesn't have a work permit, so she's being paid under the table, perhaps. She was promised decent wages and safe working conditions, but instead she was coerced into working in abusive conditions. So her employer threatens her that, well, if you leave, we're going to report you and you'll be deported, or you owe us money, or you can't escape. I mean, it depends on the situation, right? But this is what we call human trafficking. And this meets criteria for labor trafficking. And victims of trafficking qualify for a T visa. So the T visa is specifically for individuals who have been victims of severe forms of human trafficking, whether for labor or sex, within the United States. So to qualify, the applicant must have been a victim of trafficking, have suffered substantial physical or mental harm, be helpful or willing to be helpful in the investigation or prosecution, and demonstrate that they would suffer extreme hardship involving unusual and severe harm if removed from the U.S. So clinically, T visa evaluations often involve pretty complex trauma. Trafficking survivors may present with chronic PTSD, dissociation, depression, learned helplessness, profound mistrust, somatic symptoms, shame, fear, and there are typically layers of coercion, psychological manipulation, debt bondage. That means, and this is very often the case in cases where they were brought to the U.S., which is no longer a requirement for a T visa, by the way. But in many, many cases, they were lured into coming to the U.S. by being promised that they were going to have this amazing job and get their papers and all that. And then once they're here, they are made to pay back whatever the abuser invested in bringing them here. So that's what debt bondage is. Now you have to, okay, here's how much we're paying you, but we're deducting to pay us back for bringing you here. And also we're deducting your lodging if they're staying with them, and the food and, anything they can tack on to that bill. And so they end up with very, very little money, and which is not enough for them to be independent. So in essence, they are trapped. Sometimes there's also threats against family members, especially when they're also undocumented, etc. So these evaluations often require a nuanced understanding of trauma and coercive control. Now, unlike other immigration evaluations, trafficking cases may involve extended periods of exploitation, which can deeply alter a person's sense of safety, autonomy, and identity. So our role is to carefully document the psychological consequences of the trafficking, the impact of coercion and control, any ongoing trauma symptoms, and the risks associated with removal. Because returning a trafficking survivor to an unstable or unsafe environment can carry significant psychological consequences. So again, we're not making legal arguments. We are documenting a psychological reality. And in both U visa and T visa cases, our evaluations help decision makers understand the depth of harm that may not be immediately visible in police reports or other affidavits. Now let's talk about asylum. Asylum is one of the most well-known and often misunderstood forms of immigration relief. A person may qualify for asylum if they have suffered past persecution or have a well-founded fear of future persecution in their home country. But not just any danger qualifies. So the persecution has to be on account of one of 5 protected grounds, and that is race, religion, nationality, political opinion, or membership in a particular social group. And that legal framework matters because asylum is not about general hardship or poverty. It is about targeted persecution tied to identity or belief. So now imagine, well, in this case, not Sophia, but maybe her cousin, right? So her cousin becomes politically active in Mexico. He joins a group opposing the government. He begins receiving threats. He's followed. He's beaten by individuals connected to local authorities. So he flees to the United States. In an asylum case, the court is trying to answer very specific questions. Number one is, did the persecution occur? Was it connected to one of the protected grounds? And is the fear of returning credible and well-founded? And this is where mental health professionals can play a crucial role. In asylum evaluations, we're often asked to document trauma symptoms that resulted from persecution or torture in some cases, to assess consistency between reported events and psychological presentation, to evaluate things like PTSD, depression, anxiety, or other trauma-related disorders, to explain sometimes the delayed disclosure or any inconsistencies that may stem from the trauma, such as their presentation, to provide context and an explanation for any gaps in memory or dissociation or avoidance. And this is important because trauma does not always present neatly. We know that, but the adjudicators don't. So survivors may struggle with fragmented memories, or they might avoid discussing certain events, not want to talk about them. They might appear emotionally flat when describing horrific experiences. They might minimize or normalize the abuse even. So without clinical context, these reactions can be misinterpreted as evasiveness or lack of credibility. So part of our role is to explain how trauma affects memory, affect regulation, and the narrative organization. Now, we're not determining whether the events occurred, that's the judge's role, but we can assess whether the psychological presentation is consistent with the type of trauma that was described. Now, another critical issue in asylum cases is timing. So, in general, individuals must apply for asylum within 1 year of entering the United States, and sometimes they don't. And when that happens, an attorney may refer them for a psychological evaluation to help explain why. So, things like severe trauma, depression, dissociation, fear of authority figures, cultural stigma around mental health, all of these can contribute to delayed filing. And our evaluation can help contextualize that delay in clinically meaningful terms. So asylum evaluations often involve some of the most intense trauma narratives that we hear in this field, such as torture, political imprisonment, gang violence, religious persecution, gender-based violence, threats against children. So these evaluations require careful pacing, trauma-informed interviewing, and attention to the client's emotional regulation during the process. They also require objectivity and restraint. We are not advocates. We are not investigators. We are not to determine whether they meet criteria for asylum or not. We are clinicians documenting psychological impact. And when done well, an asylum evaluation can help a court understand the invisible injuries of persecution, the anxiety that doesn't just turn off, the nightmares, the hypervigilance, the fear of being sent back. And in many cases, that evaluation helps translate trauma into language that the legal system can recognize. And again, that is where psychology and immigration law intersect in a very powerful way. Now, along with asylum, there's other forms of relief that are very similar to asylum: withholding of removal, Convention Against Torture. I'm not going to get into the nitty-gritty of that. They're all very similar and fall under that same umbrella for us clinicians. Legally, it's very different cases. Now, there are other immigration evaluations that involve assessing competency to participate in immigration proceedings, rehabilitation in cases where a person has some kind of criminal history, risk assessments for bond hearings, and disability exceptions for naturalization. That is for certain individuals who have qualifying disabilities, and so it allows them to be exempt from the English and civics exam for citizenship. In those cases, which only psychologists can actually certify, it's a form, it's not a report that you write, it's just a form, and we're assessing cognitive or psychological conditions and document how they impair their ability to learn or demonstrate required knowledge. So, wrapping this up, mental health professionals, as you can see, we can play a crucial role in immigration law by assessing emotional and psychological hardship, evaluating trauma, substantiating abuse, assessing competency, evaluating rehabilitation, certifying disability exemptions, but here's what makes this field so unique. There are not many clinicians doing this work, which means that your report can have enormous impact. I have had attorneys tell me that an evaluation was the turning point in a case. I've had clients cry in my office because someone finally documented their story in a way that felt validating and meaningful. So it is clinically rigorous work. It is legally nuanced work, but it is deeply human work. So if you're at a stage in your career where you want meaningful impact, flexibility, a financially sustainable niche, and intellectually engaging forensic work, then immigration evaluations can offer all of that. Every case is different, every story is different, and the emotional reward of knowing your work helped keep a family together or keep somebody safe is unlike anything else. So, in closing, Sophia's story and the many variations of it highlight just how powerful our role can be in immigration proceedings. So, if today's episode sparked your interest, I encourage you to download the workbook. You can go to psychevalcoach.com and click on the top banner, and a copy will be emailed directly to you. And if you're ready to go deeper, you can explore our online courses where I teach you how to conduct these evaluations effectively, ethically, and confidently. So thank you for listening. Please share the episode with somebody who might be interested, because together we can make a meaningful difference in the lives of individuals and families navigating the immigration system. Take good care. I appreciate you spending time with me today. Make sure to subscribe so you don't miss the next one. And if this episode helped you, share it with a friend. See you in the next episode.